Imagine how it would feel for you to be the subject of the next viral video. There are times where this can't be prevented. People have the legal right to film in most areas, and cell phone cameras are everywhere. But is there anything that you can do to help protect yourself and your family from your department releasing your face to the media? The answer is yes. This week's topic covers a common sense step that officers can take to protect themselves and their families from departments releasing videos and photographs of officers without the officer's permission. I'm Steve Serbalik, and I'm a panel attorney with ARS Cops in Arizona. ARS Section 28-454 allows police officers to submit a request to prohibit the MVD from releasing the photograph of a police officer who submits a record redaction affidavit. For the purposes of this section, state law defines photographs as still photographs, X-ray films, videotapes, motion pictures, and digitized electronic images. In other words, it's pictures, videos, and really any other visual images of a person. The typical affidavit includes a statement that the officer believes that his or her life or safety, or that of the officer's family, is in danger of physical harm if the release of the officer's image occurs, because criminals and other members of the public have been known to target officers and family members. Additionally, the affidavit allows the officer to state that restricting public access to the officer's image reduces the danger of harm because it allows the officer's family to be out of the public, while off duty, without attracting the attention of criminals or others. The affidavit is then submitted to the Superior Court, often in a batch with other redaction requests, for review by a judge. If a court order is granted, state law also says that a law enforcement agency cannot release the photograph of an officer who has a redaction order pursuant to ARS Section 28-454 in effect. In fact, ARS Section 39-124 makes it clear that any person who knowingly releases a photograph of a police officer with the intent to hinder an investigation, cause physical injury to the peace officer or the officer's family, or cause damage to the property of the peace officer or officer's family is guilty of a Class 6 felony. Because the affidavit required to get the order already establishes the potential for a danger to the officer, and the court signs off on the affidavit is sufficient for establishing that risk, I'd argue this automatically establishes that it's illegal and potentially felonious for a government employee to release an officer's image when a court order protecting that information is intact. Also, remember that although this section refers to photograph, state law states that for the purposes of redaction requirements, photographs include video, and obviously video includes body-worn camera footage depicting the officer's face, which means that departments that want to release body-worn camera video of critical incidents have a legal obligation to, at a minimum, blur the faces of officers with protective orders in place. The bottom line is this: the legislature established a process for officers to both do their jobs and to protect their families while they're off duty. Officers can and should work with their departments to get protective orders that allow officers' likeness to be withheld from public records releases, including release to the media. If you have any questions or comments, please leave them down below. Like, subscribe, and hit that notification bell to help my channel grow. Please share this video with others that might find it helpful, and be on the lookout for future videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching, and stay safe out there.